Good morning, afternoon, or evening. Your video is about to start. I wanted to remind you of our newer Wednesday, 1 p.m. live stream Q&A on all things Social Security. Visitors are welcome to post a question in the chat, and I'll do my best to answer it. It's on a first come, first serve basis, so please get there on time. Otherwise, if you care to be a member and get some different kinds of perks, feel free to click the join button below or just click it to learn about them. Anyway, I hope to see you Wednesday. If not, enjoy the video. Bye now. Good morning here, or afternoon or evening, depending on when you're watching this. I am reaching out to you from Perry County, Pennsylvania, about a half hour away from Harrisburg. Anywho, this one is about something that came up this morning, and it's going to put a little slight delay in the application. It's not going to have any bearing on back benefits by delaying the application. It should only be a few days. Plus, we have a protected filing date. However, this comes about when there's various questions in the application that can be confusing, and it's about when you became disabled versus when you stopped working versus, and the dates don't necessarily coincide. So in this particular instance, well, there is some confusion with a couple different answers on when the actual work stoppage is because the person was originally didn't read it that way and thought it was when did I stop being a on the books employee for the employer, and that's not really the question. Sometimes employers, that's just paper's form, not substance. When did you stop working? When's the last time you attended that job? If you were just a person on medical leave, that part doesn't count. You're not at that job working. So if you say, well, they kept me around, they finally terminated me. It doesn't matter when they terminated you or when you finally quit. When did you actually stop working? When did the actual work stop? Not when you felt disconnected from that employer with that relationship. And then sometimes, and this is another one, this is all in this one particular case, the person receives money that appears to be from that employer, and it's showing up in whether it was a 1099, but it shows up in income in a subsequent year on their earnings report that you can download from your SSA account online, which you can usually get through via login.gov, as we know now, and id.me. And so if you see, now you say you stopped working in 2019, but they're showing $20,000 received in 2020. And then when you go look at your tax returns, you see you have a 1099 or a W-2 in 2020, it would suggest, because if it's showing up in the earnings report, it means generally that there was Social Security taxes withheld. Because Social Security taxes are only withheld on that portion of income that is from work activity, leads the SSA to understandably think that you must have worked in 2020. But sometimes that is not the case because an employer made a special payment of some kind. It could be a settlement of a legal case. Maybe you had an employment lawsuit against the employer and they made a payment as a settlement, and I don't know from tax purposes why this is really permitted. If they're paying you a settlement, why are their FICA taxes being taken out? Now, I say that, but it can be good sometimes if the FICA taxes were taken out for Social Security and Medicare because it now extends your date last insured an extra probable year that it would not otherwise have been extended, which in this particular case is critical because 2020, 2019, that person is no longer insured. 2020, if there's income where Social Security taxes were paid, that person is now insured through the end of 2025. Not my ideal kind of client situation for them to have a DLI that soon, but it's better than being end of 2024. But again, if you are claiming to be disabled and you need to fill out these varying dates, remember that you're not really, if you're working full time, even if you feel like crap, you're not disabled under the law. Now, they do also ask questions such as, and this is where it gets kind of in the weeds, like we have to do a lot of weaving here to get everything to be understood, and we document it separately so we have an understanding, when we haven't looked at the case in weeks and what was going on with that. It can be where you were feeling very disabled and your hours were getting shortened, you weren't showing up, you're still on the books and you're still getting full pay or SGA pay, but things have changed. They take away a duty from you. Everyone's just trying to make it work, so to speak. There is an area kind of differently for that. And I think, but it can really make you have to do a bunch of other reports and you're never going to get paid as if you were disabled back then, unless it is considered subsidized work. Subsidized work is a very, very unique animal, and it requires an employer going out on a limb and filling out a form saying, oh, yeah, I subsidized her. She got paid this, but she really, we just did it out of kindness, and she wasn't really working to that amount. And the amount she was working would only have been worth X amount. And if that X amount was under SGA, despite the fact that they paid you more, you could feasibly say that was a disabled period of time, and that excess pay wouldn't necessarily count as an undisabled time based on the monies because your employer is saying it was subsidized. However, that would be very, very rare, except in those kind of exceptional circumstances where employers do deliberately and knowingly assist someone. Usually it's out of pure kindness. Sometimes it's very severely disabled individuals who really wouldn't be able to. A lot of times it's cognitive, severe learning disabilities, cognitive losses. They need complete oversight supervision. They're not really doing anything majorly of substance where they'd ever get a job anywhere else. It might just be the friendly face in the office or at the store who says hi to customers. I mean, something very, very simple that might not generally garner a paycheck. But so for the rest of us, when we're plugging through the last year or two, assuming we have progressively getting worse disabilities and we are still on the job and getting paid, but we know we're not pulling our weight. We're like, oh my gosh, we're so fearful that we're going to be out of a job and how are we going to support ourselves and all that, particularly we haven't saved. That's where those questions can get confusing. And if it's not necessarily appropriate or helpful to talk about the failures to do a good job in that vein, because now they're going to have you go back and do like an 821 form where you have to describe how, what kind of reduction in work did you do? If it's your own slacking and it's not really an official subsidization, and you were taking home more than SGA, it might just be a waste of your time to go into those details. And there is a difference between not being able to do the job you're supposed to do versus getting it subsidized in the pay. It's not even the same as an accommodation. Anywho, we are getting this straightened out. It's taken a little while because, well, I probably should just pick up the phone. I've been messaging. But as you can tell, my voice is a little wonky. It's gonna be a long day. Today is our Wednesday live stream Q&A, and I will be there at lunchtime, 1 o'clock p.m. Eastern Standard Time. Sounding like this, I'm sure I'll have my water, my Gatorade. I probably shouldn't have the Gatorade, but sometimes the water gets a little old, and I don't know, maybe some throat lozenges or something. Anywho, be careful about when you left work and getting the right day. And if they paid you money that wasn't from work, that doesn't mean you have to make your onset date after they stop paying you. If you were not working 2 years prior to that and you're just on their books and maybe they paid you some unpaid vacation or you had a lawsuit or anything like that, you want to recognize that that is not work activity and you stop before then. So your onset date could be before then if the shoe fits, if your medical problems were such. Similarly, you could have gotten pay from a different source, maybe a LTD company, long-term disability that you got paid through. Usually those 1099s, I believe, are going to say what they're for, disability, and that proves that it wasn't for work. But you want to keep all that stuff because it's going to come up usually. SSA will ask you about it, and you'll be like, blah, what? And so you want to have it and just calmly address it, and it's not a big deal. But it takes us a little bit extra work and a little extra time, and calmly doing it. Okay. So that's what we're doing now. I'm trying to figure out when this onset's going to be because it seems to be bouncing and I want to get it perfectly right the first time. Because if you get it later than it should be, if you put in later than it should be or could be, it is very hard to get City Hall to change that date. Extremely hard on initial and recon. I write to them. I say, oh, so-and-so made a mistake, with the information and this needs to be, the onset should be the year before or 10 years before or whatever it is. Getting a live body to do that is like moving a mountain. Now, if you're going before an ALJ, they are very receptive to doing so. If that did happen and you see that you have an inappropriate or incorrect alleged onset date when you're heading into the hearing, I would write a letter to give them notice ahead of time, way before the hearing, preferably, and then bring it up at the hearing. When he says, is there anything before the hearing we need to discuss? Yes, I wrote a letter on so-and-so date explaining why I think my alleged onset date should be different than what I first thought it was going to be. And it could be a technical reason, and then proofs came up later, or it could be a complete typo. You just don't know. It's all human. So anyway, it's something you can correct. But if you're going to try to do it on initial and recon, just try to do it right before you apply because chances are they won't correct it. And when they make a determination, let's say it's in your favor, they're never going to look at that old period of time. And then you're at the dilemma of, gee, do I appeal this win I just got because, I really wanted that earlier alleged onset date. What if they were to agree with me about the earlier alleged onset date if they now considered it? You could probably do that. But remember, every appeal opens up the whole case. And that new person working on your case, which will not be the old one, it'll be a reconsideration if you're on initial, or it would be a judge, might see things totally differently. Maybe you will have improved as far as I can tell, and they're not going to award you and they're going to flip it. So appeals always have their risks. We do them with great care and analysis before I recommend them, number one. Number two, it's usually well, this is the risk and this is this, et cetera, et cetera. Anyway, I think I have to go sneeze, so I will talk to you guys later. Have a good day. Bye. Thank you for joining and taking a listen to this video. If you have any questions that relate to this or anything else with regard to Social Security, disability, retirement, SSI, etc., please do feel free to post it in the comments below, even if it's not necessarily related to this video. And I will see them. And if it's something I can do a video on, I will be happy to do that. If you are looking for representation in a current battle to prove that you are disabled, whether you have applied yet or not, and ideally, if you have not applied yet, that's when we like to come in and start from the beginning and do our wonders. You can go to joydisability.com, look up to your left, and there's a little link for a free SSD evaluation, and we will take a look at it and let you know one way or the other. If you are looking for a consultation, not representation, or you can't get representation for whatever reason, or it's a non-representational type of issue you need to review, you are more than welcome to order a prepaid consultation. It will be with me personally, and that link is on that same page, joydisability.com, but over in the upper right. Anyway, thanks for staying tuned, and I hope to see you every day, 9 a.m. with our little video shares or live Q&A if you want to join me live on Wednesdays at 1 p.m. Eastern Standard. Thank you so much. Have a great day. Bye-bye.